What is commercial arbitration? Welcome to International Council, Lebanon. Arbitration is a private method of alternative dispute resolution, ADR. Parties agree to submit their commercial or business disputes to one or more neutral third parties, arbitrators. Arbitrators review evidence and arguments, then render a binding decision called an arbitral award. It operates outside the traditional court system, but results in an enforceable outcome. Disputes arising from business transactions, contracts, investments, etc. Why choose arbitration? A. Confidentiality. Proceedings and awards are generally private, unlike public court records. B. Party autonomy. Parties have control over selecting arbitrators, rules, language, and location. C. Expertise. Arbitrators can be chosen for specific industry or legal expertise relevant to the dispute. D. Finality. Awards are typically final and binding, with very limited grounds for appeal, providing certainty. E. Enforceability. International awards are widely enforceable under treaties like the New York Convention, crucial for cross-border disputes. F. Potential for speed and cost-effectiveness. Often faster and potentially less expensive than complex court litigation, though not always. How arbitration begins. The arbitration agreement. Arbitration is consensual. It requires an agreement between the parties. This can be an arbitration clause within a main contract, most common agreeing before a dispute arises, or a submission agreement made after a dispute has arisen. A valid arbitration agreement generally prevents parties from taking the covered dispute to court. The arbitration process. 1. Commencement. Claimant files a notice or request for arbitration. 2. Arbitrator appointment. Parties select arbitrators according to their agreement or applicable rules. 3. Preliminary phase. Procedural orders, defining issues, timetable. 4. Submissions and evidence. Parties exchange written statements, documents, witness statements, expert reports. 5. Hearing, if necessary, oral arguments, witness examination, can sometimes be documents only. 6. Deliberation and award. Arbitral tribunal reviews all materials and issues the final, binding award. The outcome. The arbitral award, its effect. The final decision by the arbitral tribunal typically includes reasons for the decision. Binding. Parties are legally obligated to comply with the award. Limited recourse. Grounds for challenging an award in court are very narrow. Enforcement. Can be enforced through national courts, often facilitated internationally by the New York Convention, ratified by over 160 countries. Thank you for watching this brief about commercial arbitration. International Council, Lebanon, your partner in dispute settlement.